Courtney Clenney. Would the party please state your appearances for the record, starting with the state?
Yes, Your Honor. Sean Abuhoff on behalf of the state, Kathleen Hogue on behalf of the state, and then on behalf of the next of kin, Mr. Larry Hanfield.
Good morning. And on behalf of Ms. Clenney?
Good morning, Your Honor. Frank Prieto on behalf of Ms. Clenney, along with my co-counsel, Ms. Sabrina Puglisi, and Ms. Diane Karames. Ms. Clenney is present in custody, Your Honor.
And also, Judge, I apologize for interrupting, but also the next of kin is present. Mr. Hanfield is going to introduce them.
All right, thank you.
Yes, please stand. First, we have the mom, Mr. Christian Obumseli. We have the brother, Jeffrey. Could you please stand? We have Karen. And we have other family members, Auntie. We have Clara. And we have Sandra.
Thank you all so much for being here today. Thank you.
And Judge, just for the record, she's printing on page 2 of Your Honor's calendar.
Yes, sir. Thank you. Mr. Abuhoff, I understand the state will be filing an amended information at this time.
Yes, Judge, and in anticipation of this plea, the state has filed a amended information charging the defendant with 1 count of manslaughter with a deadly weapon. It is a first-degree felony, punishable up to 30 years in state prison. That changes her guideline score from what it was to now 124.5 months in state prison, up to 30 years in state prison.
All right. Mr. Prieto?
Yeah, Judge, we've entered plea not guilty, demand discovery, and request trial by jury at this time.
That being said, I understand the parties have reached a resolution in this case where Ms. Clenney will be pleading guilty. Is that correct?
That is correct, Your Honor.
All right.
That is
Mr.
correct, Judge.
Abuhoff?
I am passing up the written plea agreement that is signed by not only the state, the defendant, but also all of her attorneys. Major part of this, Judge, is that she's pleading guilty to this amended information, to the charge that was announced just now. There's a factual proffer that's a part of this plea agreement. We're going to ask Your Honor to read it. She will be agreeing to that factual proffer, but most importantly, she is agreeing and admitting that she is the cause of the stab wound that Mr. Obumseli received, and then that she is taking criminal responsibility for her actions. As part of this plea agreement, the state is willing to accept her plea. We've discussed this at length with the next of kin and certainly with Mr. Hanfield. And certainly when there's any agreement, no one is happy at the end of this, and we understand that. But the agreement that the state is willing to accept is that the defendant would be adjudicated guilty. She'll be sentenced to 6 years in state prison, followed by 5 years of reporting probation. As part of her probation, she must complete a mental health evaluation and treatment. There's a time frame in which she is to complete it. That's part of the plea agreement. Substance abuse evaluation and treatment. That's also a time constraint that's going to be in the agreement. And then it's 60 days, Your Honor. And then the batterer's intervention program. If she does violate her probation in any way at any point, she's waiving extradition back to Florida, and as well that she faces back to her guidelines, which are 124.5 months in state prison up to 30 years in state prison. Although not specifically in this plea agreement, the state attorney has asked me to discuss the topic specifically that it discusses, and it's important that nobody who is a convicted murderer to killing someone, if someone is convicted of murder, they are not to financially benefit as a result of that. That's Florida Statute 944.512. It's effectively our iteration of the Son of Sam law, but it is a statutory lien that attaches automatically, and if the Attorney General's office were to decide to seek some form of lien or process in that, then that we would be supporting them in that. We do believe that nobody should benefit financially from murdering somebody, so we will provide any evidence that they request. We'll work hand in hand with the Attorney General's office if they so seek to do some form of lien or some financial proceeding against Ms. Clenney, understanding that she will be released at some point and may seek to financially benefit as a result of this. But it's not part of the plea agreement, but it is something that attaches automatically.
All right. Mr. Prieto, I'll hear from you as to the plea agreement in its written form. Is that your understanding of the plea?
That is correct, Judge, and all the conditions and all the agreements are contained within that document. outside the four corners of those the multiple-page document, we do not agree that, number one, 944.512 is constitutional. We reserve our right to challenge that.
At this point, that's not part of this proceeding. It attaches automatically. It is constitutional. It is the law. What they do subsequent hearings is to them. But as we stand here today, because it does attach, I'm just simply announcing that we will work hand in hand with the Attorney General's office. It needs no further discussion, but the fact is that no one should financially benefit from murdering somebody.
Well, Judge, I do have the right to speak on my client's behalf, and so I'm going to put on the record that we believe that statute's unconstitutional. It's not an issue for the plea agreement, like Mr. Annabelle said. It is 100% accurate. However, we reserve the right to challenge that in the future. We do not think it's constitutional, and it would be challenged should any Attorney General seek to enforce that, but that's an argument for another day should it arise.
All right, very good. In preparation for today's proceedings, I have been privy to the agreed upon plea, and I will ratify the agreement of the parties at this time based on the following. This case originated 4 years ago in 2022. Since then, the parties, both the state of Florida and the defense in this case, have engaged in diligent and extensive preparation of the case. That preparation consisted of a thorough investigation that included, but was not limited to, the routine discovery process that is involved in a complex criminal case, as well as literally thousands of pages of legal motions and responses, the consultation of experts from both sides who opined on various legal issues, such as self-defense, battered partner syndrome, and issues regarding manner of death. Based on the investigation of the case and the resulting legal analysis of the strengths and weaknesses of this case from both the state's perspective as well as the defense, and perhaps most importantly, the victim's family's wishes to bring closure to this horrific and life-changing experience, the parties have reached a resolution that this court will not frustrate. The parties have also agreed on a factual proffer, as stated by the prosecutor, that I will now read into the record. The state of Florida and the defendant agree as to the following factual proffer. A. Christian Obumseli, hereafter the victim, and the defendant began dating in late 2020. Their relationship is defined by the parties as being extremely tempestuous and combative, as both have been involved in numerous domestic violence incidents. B. The victim and the defendant moved to South Florida in January 2022, taking up residence in a condominium located at One Paraiso Residences, located in Miami-Dade County. There were many complaints made by residents and security staff lodged against the couple during the 3 months that they resided in the complex. As a result, the management company was in the process of evicting the couple. C. On April 3rd, 2022, Miami Police and Miami Fire Rescue responded to their condo after a 911 call was made reporting a stabbing. Officers found the victim with a singular stab wound to the chest. After the incident, the defendant provided a knowingly, intelligent, and voluntarily made statement to the police, confirming that she was responsible for the stab wound. The knife penetrated approximately 8 centimeters into the victim's chest, puncturing the right subclavian artery. The victim was transported to Jackson Memorial Hospital, where he died from his injuries. Madam Clerk, would you please swear in Ms. Clenney?
Yes, Your Honor. Raise your right hand, ma'am. Do you solemnly swear affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
You can put your hand down. Please state your full name for the record.
Courtney Clenney,
What is your date of birth?
4/29/1996.
How far did you get in school?
I have no GED.
Do you have any history of mental illness?
I was diagnosed with severe PTSD.
Are you currently under the influence of drugs, alcohol, or medication?
No, Your Honor.
Have you understood everything that was discussed with your attorneys prior to coming to court, as well as what we're doing here in court today?
Yes, Your Honor.
I understand you wish to plead guilty to manslaughter in exchange for the plea that was read into the record a moment ago. Has anyone, including your own attorney, promised you anything other than that?
No.
Has anyone forced, threatened, or coerced you to accept a plea at this time?
No.
Do you understand if you are not a United States citizen, this plea will result in negative immigration consequences such as deportation or removal?
Yes.
Have you spoken to your attorneys about that, and do you still wish to accept this plea knowing that?
Yes, I do.
Do you understand you're waiving your right to a trial?
Yes, I do.
Do you understand you're waiving your right to remain silent and that silence cannot be used against you at trial?
Yes.
Do you understand you're waiving your right to testify?
Yes.
Do you understand you're waiving your right to confront, cross-examine, and present witnesses? Do you understand you're waiving your right to hold the state of Florida to its burden of proving the case beyond a reasonable doubt?
Yes.
Do you understand you're waiving your right to appeal? The following question does not seem to apply in this case, but I have to ask in every case. Do you understand if the offense to which you are pleading is a sexually violent or sexually motivated offense, or if you've been previously convicted of such an offense, this plea may result in involuntary civil commitment as a sexually violent predator upon the completion of your sentence?
Yes, I do.
Do you understand if you violate the terms and conditions of your probation, you're facing up to 30 years in the state prison?
Yes, Your Honor.
Do you still wish to plead guilty?
I do.
Are you pleading guilty because you are in fact guilty and you believe this plea is in your best interest?
Yes, Your Honor.
Have you spoken to your attorneys about the plea?
I have.
Have they answered all of your questions?
Yes.
Do you need any more time to discuss the plea with your attorneys?
No, Your Honor.
Are you satisfied with their services?
I am.
I'd like to talk to you for a moment about the written plea agreement that I have in my hands. It is 8 pages, and on the bottom left of each page, it says defendant's initials, CC. Are those your initials?
Yes, Your Honor.
Have you reviewed every line, every word, every page of this plea agreement with your attorneys?
Yes.
Now turning over to page 6 of 8, it's entitled Defendant's Representation of Effectiveness of Counsel. Is that your signature over the line that says Courtney Clenney, defendant?
Yes, Your Honor.
And then each of your attorneys has also signed on pages 7 and 8, Mr. Prieto, Ms. Laura Puglisi, and Ms. Karamas. Are those your signatures?
Yes.
Yes,
Yes, Your Honor.
And finally, certificate of defendant on page 8 of 8. Once again, Courtney Clenney, defendant. Is that your signature on that line?
Yes, Your Honor.
Do you understand that even if I do not state orally here on the record that everything contained within this written plea agreement will be made part of your judgment and sentence, even if I don't say it out loud?
Yes.
Mr. Prieto, have you and your team reviewed all items of evidence disclosed by the state with Ms. Clenney?
We have.
Do the state or defense know of any items of physical evidence containing DNA that could exonerate the defendant? State?
No, Your Honor.
Defense?
None of
Does the defense waive PSI?
it. We waive PSI.
Do the state and defense stipulate to a factual basis? State?
State stipulates.
Defense?
will stipulate as contained in the plea agreement.
Ms. Clenney, I find the plea has been entered into knowingly, voluntarily, and intelligently. That you understand the nature and consequences of the plea, there's a factual basis for the plea, and that you're represented by good and competent counsel with whom you say you're satisfied. At this time, I will be adjudicating you, and I'm going to turn to page 3 of 8, to the charge of manslaughter with a deadly weapon. I'm sentencing you to 6 years in the state prison with all applicable credit for time served, followed by 5 years of reporting probation. As a condition of that probation, you will complete a mental health evaluation and all required treatment deemed necessary. You will complete a substance abuse evaluation and complete all required treatment deemed necessary, as well as completing the batterer's intervention program within the first year of probation. As I said, there are some other provisions contained within this written plea agreement that will be made part of the judgment and sentence. I'm assessing court costs and any and all statutory and mandatory fines. You will be fingerprinted. We should have DNA on file. Before we turn it to the victim impact portion, is there anything further on behalf of the state?
Nothing from the state, Judge.
Defense?
Yeah, Judge, I would just, as far as corrections and computing her time served, to remember she was initially detained in Hawaii when she was in the rehab facility, so her actual booking date here at TGK does not reflect all of her credit for time served. I don't have the date of arrest, but I believe the date of arrest in Hawaii was August 10th of 2022, so she should receive all credit for time served from that date moving forward.
Does the state agree?
But Judge, the only issue is going to be, one, there has to be an order for it. Otherwise, it's
I'm
going.
happy to sign the order.
Otherwise, it's going to be from the time in which she was brought into custody. So,
Right, so if you're in agreement, let's draft an order, credit for time served on August 10th, 2022.
We will do that. We'll have it to your honor today.
All right, anything further on behalf of the defense?
No, Your Honor.
All right, I'm filing the written plea agreement that I have now initialed and executed with the clerk. I'd like to now turn it over to Mr. Hanfield. But first, I would like to extend my deepest condolences to the Obumseli family. As I said previously, thank you all for making the time to come here today, and I'm very, very sorry for this.
Judge, actually, before Mr. Hanfield speaks on behalf of the entire family, I believe we have Ms. Karen Aguna, who is going to be reading the victim's mother's statement to the court.
Thank you.
As I stand here to read my victim impact statement, I first give thanks to the Lord Almighty for His protection and guidance over our family throughout these past 4 years. I also want to thank the attorneys, the State Attorney's Office, Larry Hanfield, and everyone who helped make sure that Christian's voice and our family's voices were heard. I thank our family and our friends who called, prayed for us, checked on us, and stood beside us through this very, very difficult journey. I am Christian's mother. Words can never fully explain how Christian's death has affected my life and the lives of everyone in our family. There is simply too much pain to put on paper. On April 4th, 2022, while I was at work, I received the call that no parent should ever have to receive. I was asked to give consent for my son's eyes to be donated. I had just talked to him the day before and had no knowledge that he had been killed. That was the darkest day of my life. And the darkness continued to unfold as I learned Christian had been killed by his girlfriend, Courtney Clenney, someone he had trusted and loved. Since April 2022, I have lived with fear, anxiety, sleepless nights, heartache, and more tears than I could ever count. 4 years later, there are still nights when I cannot sleep. There are moments when my mind goes back to the last moments of Christian's life. As his mother, those thoughts are very difficult for me to carry. There was a joy in my life and in our family's life before Christian died that has never completely returned. His death did not only affect me, however. It affected my entire family, including his older brother, Jeffrey, his cousins, who were raised as siblings, and his grandmother, who loved him so much and called him her precious. We have all had to learn how to live with the empty place that cannot be filled. But I do not want Christian to be remembered only for how he died. Christian was my son. Everyone who knew Christian, who truly knew him, can attest that he was kind-hearted, compassionate, friendly, and respectful. He cared about other people. I remember one day when Christian and I were driving to a store. I stopped and I was going to give a homeless man a few dollars. Christian encouraged me to do much more than that. It was a small moment, but it showed the kind of heart he had. He saw another human being who needed help, and he wanted to make sure that that person had enough. Christian, I'm so proud of you. I'm so proud that I had the privilege of being your mother. Those are the memories that no one can ever take from us and me. Nothing can erase the pain of the day that I buried my son. Nothing can describe what it feels like for a mother to stand at the grave of her child. There are also the things that will never happen for me now that he's gone. The birthdays, the holidays we will not celebrate with him, the conversations we will never have, the person he would have continued to become. Those losses continue much longer after today's court case ends. For more than 4 years, we've lived with the loss every day and waited for accountability. Today closes a legal chapter, but it certainly doesn't close our grief. No sentence, no plea can bring back my son to me. My only hope is to carry his memory forward and to continue healing as a family. My prayer is that after today, Christian will simply not be remembered by the public as a name connected to a criminal case. He was a son, he was a brother, he was a cousin, he was a nephew and a grandson, and he was a friend to a lot of people. He was loved, he had a future, and his life had value and mattered. As a family, we are very private people. We have endured this loss while much of Christian's life and death have been discussed publicly and inaccurately to support a narrative created by Courtney, the person who took my son's life. There are parts of our grief that belong only to us, and I choose to keep those things within our family. But I want this court to understand this much. The loss of Christian did not end on April 4th, 2022. We carry it with us every day. Through everything, I continue to place my faith in God. Christian Obumseli, I know you are with the Lord. Onwa Tilora, as your brother called you, which means the moon in the sky that shines for everyone. That is how I choose to remember you, as a light. Your legacy and your memory will remain with us. We miss you. We love you. May you continue to rest in peace, my son.
Thank you for those beautiful words.
May it please the court. State Representative of the State Attorney's Office, Courtney Clenney. On behalf of the Obumseli family, I would like to read into the record their final comments. April 4th of 2022, Christian Obumseli suffered a painful and tragic death at the hands of the person he loved. Sadly, that will be the person that would ultimately take his life. Christian loved deeply. It was his love that caused him to stay. Even after being previously cut in the face, previously stabbed in the leg by Courtney, he would later write that his love would eventually get him killed. In many ways, he predicted his own death at the hands of Courtney Clenney. Unfortunately, like so many individuals who will get caught up in not loving relationship, but just destructive relationship, he stayed. And we are here today because what he believed became a reality. By resolving this case today by way of a plea, Courtney Clenney avoids being judged by a jury of her peers. But that will never be able to escape the ultimate and final judgment for anyone's conduct. That judgment can only be handled by our Creator, our Almighty God. Your actions, you need to know, as you sit here today, and as you finish out serving your time for punishment, that you have left the Obumseli family with a void that can never be filled. The pain that continues to endure today as painful as it was when they learned of his untimely death. It is a pain that will never completely go away. A chair where family gathers for holidays will always remain empty. The Obumseli family has been forced into joining a membership that no family should ever want to be a part of. And as a family of mothers of murdered children. As a family, we still cannot get past the fact that Christian was stabbed while you remained on the phone with your mom. You then called downstairs to security, and then your third and final call, which should have been your first call, was to 911. In the meantime, you offered no life-saving measures to try to save Christian's life. To us, that is inhumane. Christian was someone's son, someone's brother, someone's nephew, someone's cousin, someone's friend, and most importantly, he was deeply loved. His life had meaning. He had a future. And his family deserved to grow old with him. He was robbed of all those things while you still have all yours to enjoy. Nothing can bring Christian back. Nothing can erase what happened. And nothing can fill the space that will forevermore be left empty. We will carry Christian's memory, his love, and his legacy with us for the rest of our lives. I thank the court for giving us, as a family, the opportunity to be heard and to let this be a part of the record. But lastly, through it all, we never even received an apology, an acknowledgement for the loss that changed our lives forever. Thank you.
Thank you, Mr. Hayfield. Would anyone else like to speak at this time?
I don't believe so, Judge. Not from the state.
Once again, for the entire family, thank you for being here. Thank you for the beautiful words that you read and what Mr. Hayfield read. Thank you for sharing the collage of pictures of Christian.
And that brings this courtroom chapter to a close. The defendant received 6 years in state prison followed by 5 years of probation, but the victim's family made one thing painfully clear. A sentence can close a legal case, but it cannot close a family's grief. What do you think? Was this plea agreement a fair resolution, or should this case have gone before a judge?